Welcome back to the deep dive. Today we're jumping into a really foundational piece of the MPEP puzzle.
That's right. We're in Chapter 400, which deals with the representative of applicant or owner.
And specifically, MPP Section 410. This one's called Representations to the U.S. Patent and Trademark Office.
And it's basically the rule book for how you have to behave ethically and procedurally when you submit anything to the USPTO. It all comes down to the certification standard in 37 CFR 11.010.
Okay, certification standard. That sounds important. It sounds like the basis for trust in the whole system.
It really is. Think of it like this. Every single time you sign, file, or even just advocate for a document you've submitted, you're making a formal promise to the office.
A promise about what, exactly? What are you certifying? And who has to make this promise? Is it just the lawyers?
No, that's the first key point. It's universal. Section 410 makes it crystal clear, referencing 37 CFR 1.4. It applies equally whether you're a registered patent practitioner
Or a non-practitioner, like an inventor filing their own application.
Exactly. If you present a paper, you are bound by 11.18b. Your signature, your submission, it's your certification.
Got it. So the solo inventor's signature carries the same legal weight, the same certification burden as a partner at a big firm.
Precisely. And this is super important when you're using official USPTO forms.
How so?
Well, when you submit an official form, say a terminal disclaimer or maybe a declaration, you're implicitly certifying that you haven't messed with the text on it.
You mean you can't change the boilerplate language?
Correct. Altering those pre-printed certification statements is a definite no-no. It's prohibited. And doing it could actually invalidate the entire filing.
Wow. Okay, so the office is really relying on the integrity of the submission right down to the form itself.
Absolutely. They need to trust that what's presented is accurate and hasn't been, secretly modified.
Okay, so we know who certifies. Now, what are the core things you're certifying to when you submit that document? You mentioned 11.18b2.
Right. There are two main pillars here. First, purpose. You certify the paper isn't being presented for any improper purpose.
Improper purpose, like what does that cover?
Things like trying to harass someone, cause unnecessary delay in the process, or just needlessly drive up the costs for somebody else involved in the proceeding.
Okay, that sounds like basic professional conduct, keeping the process fair and efficient.
It is. It's very much aligned with Rule 11 in federal court practice. It's about maintaining the integrity of the administrative process. You need good faith.
Makes sense. What's the second pillar? You said purpose and...
Merit. Legal merit. You certify that the legal arguments, the contentions you're making, are either warranted by existing law.
So based on current statutes, rules, case law.
Exactly. Or, and this is important, they're warranted by a non-frivolous argument for changing the law.
Okay, hold on. Non-frivolous argument for changing the law. That sounds like it could open the door pretty wide. How do you draw the line? What stops someone from just making wild arguments hoping something sticks?
The key is that word, non-frivolous. It's not just any argument to change the law. It has to be based on a reasonable inquiry, grounded in logic, and presented in good faith.
So you can argue against established precedent, like maybe challenging how Alice or Mayo applies to your invention?
You absolutely can. That might be a tough argument, uphill perhaps.
Yeah.
But if it's well-researched, logically structured, and you genuinely believe there's a basis for modification or reversal, it's likely non-frivolous.
But if you're just, I don't know, citing overruled cases or making arguments with no plausible legal basis?
That's frivolous. That's the kind of thing 11.1 is designed to prevent. It allows for evolution in the law, but it demands diligence and intellectual honesty. You can't just make things up.
Got it. So it encourages pushing boundaries, but responsibly.
Exactly. It rewards reasoned advocacy.
This ties into something else mentioned in 410, this idea of reasonable inquiry under the circumstances. Does that mean you have to do a full prior art search before you file an application? Because that's a huge practical question for inventors.
Right. And MPP 410 addresses this directly. It clarifies that while you do have a duty to make a reasonable inquiry,
which applies to the statements you make.
yes, that duty does not impose a requirement to actually conduct a prior art search before filing.
Okay, that's a big relief for many filers, I imagine. Why that distinction?
Well, the office wants to encourage prompt filing. Sometimes you need to file quickly, maybe before a really thorough search is practical or affordable. The focus of 11.110 is more on the truthfulness of the statements you do make, based on the information you have or reasonably should have investigated.
So it's about the factual assertions in the document.
Precisely. Like if you file a petition and claim a delay was unintentional, you need to have actually looked into the circumstances and have a factual basis for saying that. You can't just check the box without thinking.
It's about certifying the things you state as fact.
Yes. Your statements about inventorship, ownership, small entity status, the circumstances surrounding a delay, all those factual representations need to be made in good faith, based on credible information available after a reasonable inquiry. It underpins that whole duty of candor.
Okay. So the standard exists, it applies to everyone, and it covers purpose and merit. What happens if someone violates it? What are the teeth behind 37 CFR 11 point anything?
The consequences can be quite serious. The USPTO director has the authority under 11.0c to impose various administrative sanctions.
Like what kind of sanctions are we talking about?
Well, they can strike the paper you submitted, just remove it from the record entirely.
Poof, gone.
Yep. Or they might decide to give less weight to what's in that paper during examination.
So it stays, but it doesn't help you much.
Right. They could also preclude you, the party or the practitioner, from submitting more papers on that issue, or even stop you from contesting certain issues altogether.
That sounds like it could seriously hamper your ability to prosecute the application.
It absolutely could. And in the most serious cases, they can actually terminate the entire proceedings in the office.
Terminate the whole application. Just shut it down.
Shut it down. That's a potential administrative sanction for a severe violation.
Wow. And for registered practitioners, there's another layer of risk, right? Beyond just the specific application.
Yes, definitely. Under 11.18ED, if a practitioner violates the rule, it's basically mandatory that the matter gets referred to the director of the Office of Enrollment and discipline the OED.
And the OED handles attorney discipline.
Correct.
Yeah.
So a violation could lead to a formal investigation, potential suspension, or even disbarment from practicing before the USPTO. It's a serious professional risk.
Okay, so the immediate consequences within the USPTO are significant. But does a violation here, like submitting false information, have implications after a patent is granted? Could it come back to haunt you years later?
Absolutely. And this is arguably the biggest risk of all. Violating the certification standard, especially if it involves making false statements or intentionally omitting material information.
Preaching that duty of candor we talked about.
Exactly. That can become the basis for a charge of inequitable conduct if the patent ever gets litigated.
Inequitable conduct. That's the thing that can kill a patent, right?
It renders the entire patent unenforceable. All claims. Doesn't matter how strong the invention is. If the patent was obtained through inequitable conduct, a court can refuse to enforce it.
Are there examples where this link between representations during prosecution and later unenforceability has been shown?
Oh, yes. There's established case law. Cases like Roman Hosco v. Crystal Chemical Co. or General Electric Music Corp. v. Samick Music Corp. These precedents show that misleading statements or failures to disclose known material information during prosecution actions that clearly violate the principles in MPEP 410 and Rule 11.0T can absolutely lead to a finding of inequitable conduct down the road.
So getting the certification right isn't just about navigating the USPTO process.
No, it's fundamental to obtaining a valid enforceable patent in the first place. That integrity, that candor, safeguards the value of the patent grant itself.
It really underscores how MPEP 410 isn't just procedural fluff. It's the ethical bedrock, the duty of diligence, honesty, and good faith for every single interaction with the office.
Couldn't have said it better. It ensures the reliability of the whole system.
So, wrapping this up, what does this really mean for you, the listener? Think about this. If every single legal argument has to be backed by existing law or a non-frivolous argument to change it, and if missteps can lead to termination or even render a patent worthless, how does that shape strategy?
It forces a careful calculation, doesn't it?
Yeah.
How far can you push the envelope with a novel legal theory? The potential rewards have to be weighed against some pretty significant risks if you cross that line into frivolousness or misrepresentation.
Does it perhaps favor more meticulous, incremental arguments over truly radical, untested legal leaps? It's something to consider how this standard might influence the very nature of the arguments presented for cutting-edge innovation.
It certainly emphasizes the need for a solid, well-reasoned foundation for everything you submit. Strategy needs substance.
Absolutely. Okay, that brings us to the end of this deep dive into MPEP Section 410 and the vital certification standard under 37 CFR 11.18.
Yep.
As always, remember this is for educational purposes.
That's right. For authoritative guidance, you really need to consult the official MPP itself, talk to a qualified instructor, or seek advice from a registered patent practitioner.
And we want to give a special thank you to Mike Shepard, the creative director who's been organizing this entire series.
Thanks, Mike.
We'll catch you on the next installment of The Deep Dive.